This court unfortunately has to see many cases where vulnerable people are exploited by others. I wish it was not so prevalent. However, this needs to stop. So you're not new to this, and yet you exploited this helpless woman who was the victim in this case.
Please don't.
The court is going to order you to serve 58 days more, starting immediately.
Oh,
Ms. Turpin.
please don't do
Ms.
this.
Turpin, you are an incredibly poor risk.
I've never done this to anybody
don't talk
before.
over me. Don't talk over me. You're not going to cry your
Judge,
way out of
please.
it.
I got my
Yeah.
grandkids outside.
Are you done, Ms. Turpin, so that I can complete your sentencing?
Oh,
2024
heart
and
conditioning.
each
I have one
subsequent month.
kid.
Right here, the judge draws a hard line that a lot of defendants never see coming. This isn't a sympathy-based courtroom, and it's definitely not a stage for emotional manipulation. When the judge says, "You're not going to cry your way out of this," that's not cruelty, that's clarity. Courts see tears every day, especially in fraud cases involving vulnerable victims. What matters here is conduct, not performance. Talking over the judge, interrupting sentencing, and trying to redirect attention away from the harm done only makes things worse. This moment sets the tone. Accountability is coming, and no amount of emotional deflection is going to stop it.
All right. I don't think there's been court held in that building for 21 years.
I've never been to court here, ever. I
Well,
had no
you're
idea.
This matter comes before the court at this time for sentencing. Docket notes from June 18th indicate that the defendant pled guilty to count 3, computer crime, a level 8 felony. A pre-sentence report was ordered. Sentencing originally set for August the 12th, subsequently rescheduled to today's date. This court has received an updated pre-sentence report compiled by Ryan Smith, pre-sentence investigator, who is part of this meeting. I trust each attorney has received the updated report, and I'll ask the state's attorney first. Is there any objection to the criminal history as stated in the report?
I did receive the update, Your Honor, and no objection.
Any objection to criminal history by the defense here, Mr. Watts? Mr. Watts? You're muted.
Your Honor, no objection to the criminal history score.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score H, and the court will proceed further accordingly. Ms. Norris, do you know of any legal reason why sentence should not be pronounced in the Turpin case here this afternoon?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
Ms. Turpin, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing?
No, sir.
We'll proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Watts?
No, sir.
Very well. Are there any victims or members of a victim's family who desires to address the court in relation to this sentencing? Who is Deborah's iPhone? Or Jacqueline Green?
Your Honor, Jacqueline Green is the victim witness coordinator in the office.
Okay, all right, fair enough. And there's no family members with her?
Not that I'm aware of. And Your Honor, I'm not sure who Deborah's iPhone is.
Is there someone whose screen name is Deborah's iPhone who wishes to address the court in relation to this Turpin sentencing? I would just like to have a yes or a no.
No, I do not need to address. This is Deborah, victim's daughter.
Okay, did you wish to address the court?
No, thank you.
All right, thank you. At this time, then, the court will ask for recommendations from counsel regarding an appropriate sentence for Ms. Turpin, beginning with Amber Norris on behalf of the state.
Your Honor, state would be recommending for the felony crime of computer crime. The court follow the presumption and assign defendant to 9 months in the Department of Corrections. Defendant would be able to earn 20% good time credit and would be subject to 12 months post-release. Defendant has earned 2 days of jail time credit.
What makes this case especially disturbing is who the victim was. Elderly fraud cases are treated with heightened seriousness because they involve a clear power imbalance. The defendant didn't just break the law, she exploited trust, access, and vulnerability. Judges take that personally because these victims often can't recover financially or emotionally. So when the defendant walks in late, minimizes the process, and acts confused about basic court procedure, it signals something important: a lack of respect for the system and the harm caused. That attitude will echo throughout the sentencing, and it absolutely factors into what happens next.
And, Your Honor, this is a presumptive probation matter based on the crime and defendant's criminal history. So I asked the court to assign her to 18 months community corrections probation with all standard and PSI recommended probation conditions, including a drug evaluation, no contact, and Your Honor, this is a community corrections case, so the court will need to assess standard probation and costs of the case, but then also the community corrections fee. There is restitution in the amount of $1,305.44. Some of that goes to the victim's family, and some of it goes to the bank. We'll make sure that the dollar amounts are specifically set out in the journal entry. Mr. Watts is appointed, so the court will need to address court-appointed attorney's fees and the bid's application fee. And, Your Honor, I don't think I have any further recommendations for the court at this time.
Very well, Ms. Norris. Mr. Watts, your recommendations regarding an appropriate sentence?
Thank you, Your Honor. Your Honor, we join the state's recommendation there in keeping with the plea agreement. I believe we join the recommendation of the mitigated 9 months with the post-release and probation durations and good time credits as noted. We likewise have no objection to the restitution that is set out in the PSI. I don't know that I have a whole lot else to add, Your Honor. Thank you.
Your fees and the representation of this client?
This is billed at $1,000 for bids.
Thank you. At this time, the court will address the defendant, Patricia Turpin, personally and ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court. Ms. Turpin?
I just want to apologize to the victim's daughter. I'm very sorry for what I did, and
Okay.
I really just want to say sorry to her.
At this stage, reality should be setting in, but it clearly is. The prosecution's recommendation is standard, measured, and fully supported by the plea, yet the defendant's visible reaction tells a different story. She appears shocked, almost offended, as if consequences were optional. This is where many defendants miscalculate. A plea deal is not immunity, it's mercy with conditions. And when someone reacts poorly to accountability, judges notice. Sentencing isn't just about numbers, it's about risk assessment. And everything about her behavior here screams high risk.
Any other statements for the court, Ms. Turpin?
No.
Very well. Court will pronounce sentence in this case at this time. Court hereby establishes count 3 as the base sentence in the case for the offense of computer crime, a severity level 8, non-drug, non-person felony, in which the defendant has a criminal history score of H, thus placing her in grid box 8H. Court hereby sentences the defendant to a term of 9 months in the custody of the Secretary of Corrections, the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed on that count. Court does note that in grid box 8H, this would be a presumptive probation case under Kansas law. There does not appear to be a special rule application here or a motion. And the court will grant the defendant 18 months of initial probation term to be supervised by community corrections. Community corrections supervision is deemed appropriate due to the high risk score on the risk needs assessment that was conducted in this case. Conditions of that probation will be to report to an officer as directed, observe all laws, obtain a substance abuse evaluation within 45 days of today's date, and abide by the recommendations of that evaluation, She shall not possess or consume alcohol or illegal drugs while on probation. At her ISO's request and at her own expense, submit to random breath, blood, and urinalysis testing, perform any community service work pursuant to any program requirements, gain and maintain employment successfully throughout her probationary term, notify her ISO of any change in employment status, residence, telephone number, or email address within 48 hours of any such change happening, have no contact with the victim in this case or members of the victim's immediate family. She shall submit her DNA to the KBI databank and be responsible for the $200 cost of the test, abide by any curfew or travel restrictions imposed by her officer, follow all standard conditions of probation, not have in her possession firearms or dangerous weapons, and avoid disreputable characters and places. The defendant shall also make monthly payments on her obligations owed to the court, which would include a felony docket fee, felony probation fee, community corrections fee, the $200 DNA fee, and a bids application fee of $100. Attorney fees are waived, as the court will also be ordering this defendant to pay $1,305.44 in restitution to the victims in the case, as their interest may appear. Ms. Turpin, there's one other order that the court wishes to consider in this case. This court, unfortunately, has to see many cases where vulnerable people are exploited by others. I wish it was not so prevalent. However, this needs to stop. You are not new to the court system. You have, I believe, 3 prior property crime offenses on your record. So you're not new to this, and yet you exploited this helpless woman who was the victim in this case. And the court does have discretion, despite the fact that the legislature has determined you're not a prison case, that the court can impose up to 60 days in the county jail as a condition of probation. And that's exactly what the court's going to do here, Ms. Turpin.
Please don't.
The court is going to order you to serve 58 days more because you've got 2 days of jail time credit against that sentence.
Can we schedule it?
Starting immediately.
Oh, please don't do
Ms.
this.
Turpin, you are an incredibly poor risk.
I've never done this to anybody
don't talk
before.
over me. Don't talk over me. You're an extremely poor risk to show up in jail on any type of schedule because
I promise I will.
You couldn't even make your sentencing on time today. Further, last time you were
other building. I've never been here
at the
before.
judicial center and you didn't. Look, we're not going to talk over each other.
I've
I've made my ruling. You're not going to cry your way out of it.
Oh, yeah. Please.
All right.
I got my grandkids outside.
That apology might sound emotional on the surface, but courts look deeper. Timing matters, delivery matters, and credibility matters most of all. A quiet, last-second apology after minimizing responsibility carries very little weight, especially when it's not accompanied by ownership of harm. Judges see through performative remorse quickly. If anything, this moment reinforces the idea that the defendant understands consequences only when they're imminent, not when damage is done. That distinction plays a big role in what the judge ultimately decides.
Are you done, Ms. Turpin, so that I can complete your sentencing? Again, the court has announced 2 days of jail time credit. At some point in the future, Ms. Turpin, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any question about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, defendants have a right to appeal their conviction to an appellate court having jurisdiction. And if defendants are unable to pay the cost of an appeal, they may ask the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you, the defendant, at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Norris, I wanted to ask you, of all of the financial assessments you were asking the court to impose, has the court covered all of those?
Yes, Your Honor, I believe so.
All right. Mr. Watts, is there anything further from the defense side that the court still needs to address?
I don't believe so, Your Honor. Thank you.
All right. The court is going to order Patricia Turpin into the immediate custody of the Butler County Sheriff's
Please,
Representative
Judge, please, my
until her custody can be transferred to the Butler County Jail to serve out 58 more days.
Please don't.
And Judge, what month did you want the payments to start?
Yes, we do need to come back to that. In light of the fact that she's going to be incarcerated essentially through September and October, the court's not realistically going to expect her to make payments during those months. So the court will start her payment obligation as earlier announced for the calendar month of November of 2024 and each subsequent month
Please don't.
until her obligations are paid in full. All right. I think the sentencing proceeding is concluded at this point. Mr. Smith, thank you for your work on the case and your appearance here today, Ms. Taronis. Ms. Taronis, she's a little bit emotional right now. Do you still want to have a session with her?
Yeah, I'd like to try if I could, please, Your Honor.
All right. So I'm going to go ahead and recess this proceeding. Ms. Turpin should stay. I'll just direct court security. She needs to make contact with her ISO.
This jail time.
If
Please.
there's nothing further, the Turpin matter will be in recess at this time, and we can conclude the record and leave the Zoom meeting open for the ISO.
This is the pivot point. Everything changes here. Even though the case is technically probation eligible, the judge uses discretion to impose jail time, and that's critical. Why? Because probation is a privilege, not a right. The judge cites prior offenses, courtroom behavior, and the defendant's inability to follow basic instructions. This isn't punishment for crying, it's punishment for pattern behavior. Judges are allowed to add jail as a condition of probation when they believe supervision alone won't protect the public. And in this case, the court clearly believes that line has already been crossed.
Okay. That's not in your motion.
Oh, okay.
I do notice you filed a separate parenting plan asking for sole legal custody, I presume in your favor.
Yes.
Okay. Are you opposing this, Amanda?
Yes, Your Honor.
All right. This court had previously ordered that McDonald's visit, which apparently did not go well. I don't understand why a boyfriend was involved in it.
Can I talk?
Yes, I'm asking.
Okay. Okay. We went to McDonald's and I had my boyfriend take the kids in, so me and Jesse weren't trying to have contact. He took them in and he went into the play place with the kids, and he had one of them go out and talk to Jesse one at a time. But Jesse brought two friends along with him that decided to sit at the table with him and interact with my kids while he was trying to have his one-on-one uninterrupted time to talk to them. And when he got to my daughter, the guy he brought with him sat next to my daughter, and we have no idea who this guy is. And he just started messing with her, and
Now we enter an entirely different legal battlefield, family court. And while the tone shifts, the core issue remains the same: accountability versus excuses. Custody hearings are not about who talks the loudest or feels the most wronged. They're about stability, compliance, and the child's best interests. When a parent frames everything through conflict instead of cooperation, judges immediately grow cautious. This hearing isn't about relitigating the past, it's about whether court orders are being followed right now. And that distinction is about to matter a lot.
and I have not heard a single word from him since.
Okay, you came into the McDonald's and you were ordering people to move. And you're
Yes,
saying Jesse
yes,
was the
that's
one
what
that
he
ordered
ordered.
to stay at McDonald's?
Yes, because you ordered him to have one-on-one uninterrupted time with the kids, not to bring his friends along that my kids don't know and to sit there and mess with him.
Why did you have others with you, Jesse?
I had two people with me to video record it. They didn't
Well, it
interact.
doesn't take two people. I can see one person.
I agree. They're a couple. They didn't interact with my children at all.
Well, if they were sitting at your table, that's way too close.
Yeah, they wasn't sitting at my table. They were on the other side of the McDonald's lobby, Your Honor.
And I was trying to promote the comfort of the kids during this visit, so I would have expected Amanda, the mother, to be in there, not her boyfriend.
It goes
You honestly
better.
telling me, Amanda, you can't sit at a McDonald's restaurant, eat dinner across the room, without getting into it with Jesse?
I don't feel comfortable around him. He has put me in many situations where I don't feel comfortable. So I try to prevent that from happening. I tried to make it go as smooth as possible, and it didn't. He didn't buy them dinner, and I haven't heard from him since then. He didn't come to my son's football game the next day. He has not called, messaged, text, or nothing. And now he wants custody again, and he's not doing anything he's supposed to do.
Jesse, why haven't you followed up on additional visits?
Your Honor, I did on 2 different occasions. I came down from my dad's house in Topeka, and I tried to meet her at Quick Trip. I texted her and let her know I was there. I took video of it. And I did it 2 times. I thought, it's not worth it again. I'm just wasting my gas, and that's when I filed paperwork again.
I have not had any calls or messages from him at all, and I've had the same phone number for 5 years.
Jesse, have you ever thought about just moving closer to where the kids live?
I'm in Towanda now.
Okay.
This is one of the most misunderstood parts of custody law. Children's feelings matter, but they do not override court orders. Judges hear the kids don't want to go constantly, and unless they're proven abuse or imminent danger, it's not a legal justification. The judge is crystal clear here. Parents cannot delegate court authority to minors. When visitation breaks down, courts look at which parent encouraged compliance and which one created resistance. That's why this moment is pivotal. The judge is warning that continued interference can flip custody entirely.
And he's just getting I'm afraid for get off to the kid.
Okay. So
Just keeps bringing us
I understand that, Jesse, you're asking for sole legal custody and for primary residential, obviously, to be part of that.
Yes.
What is your current parenting time schedule, Jesse?
Every other weekend.
Friday 6 to Sundays at 5?
Yes.
Well, what I don't understand is why isn't that taking place?
Because she won't meet me at Quick Trip. She won't bring me to Quick Trip.
He has not called or texted me since McDonald's.
No, wait a minute. Whoa. Amanda, if there's a court order that already structures the visitation, you don't need a call from him. You should just be
I
there.
should know that he's coming because he hasn't came. I've been there before when we did this the first time, and he didn't show up. Like, I don't know what I'm supposed to do. My kids
You're
are,
supposed to have your kids at the meeting point at the start of his visitation periods.
and then if they don't go with him, he just leaves and takes off. He's done
If
it
they
multiple
don't go
times.
with him.
Like, he will just leave if they say they don't want to go with him. He just takes off. And so, I mean, what am I supposed to do? To go chase him down and throw them in a car with him, or like they already don't feel safe with him? So I'm not pushing for it to happen because I don't like to make my children feel not safe. I mean, my oldest is 14 years old. He has, choices in life.
Well, no, he doesn't. When he's 18, he has choices. When he's less than 18, he's subject to the same court orders as you two are. And he doesn't get to make the calls.
Okay.
As far as I know, he's only influenced by you to do all of that.
I mean, you could speak to him if you would like.
Well, and just because he tells me he doesn't want to go, that's not going to be controllable.
And
Jesse
he
has
wrote
rights
a letter
to
for
follow.
Jesse.
He has rights as
Well, they all talked to Jesse like you asked me to have them do, and explain to him what the issue is and everything, and they did that. And
Okay, when is your next scheduled weekend, Jesse?
Well, this weekend.
Okay. The place you have in Towanda, can it accommodate all of them?
Yes.
Okay. Well, what the court expects is that at 6 o'clock at your exchange time and at your exchange point, you'll both be there. All 3 kids will go with their dad for the weekend. They'll see his new place in Towanda and hopefully be properly reacclimated to it. They don't get to say, I don't want to go. Okay.
but he gets to pop in and out whenever he wants to, and just
Well, wait a
not
minute.
follow anything that he's told to do.
What we're trying to do is to go forward from here.
But we've done this.
I
3 times
wish
now.
you two could manage your children on your own. I wish I didn't have to be involved in it, or any other court didn't have to be involved in it.
If he was involved as a
Apparently you can't
father,
manage it.
then
And
it wouldn't be a problem.
Again, admonish you that if you can't handle working with Jesse, I'll put the kids in Jesse's primary care and see if he will work with you. He has just as much right to parent these kids as you do.
We did that last time he got custody of them, and he did not let me see them. He did not let me talk to them. He told me my feet stunk and I couldn't speak to my children. Like, I went a year and a half without seeing my kids because he refused to.
You were having some pretty serious drug problems?
And so was he. He wrecked his motorcycle because he was drunk driving. Like,
yeah, I'm quite aware of the whole motorcycle accident situation.
Like, he's irresponsible as a person, and he's not been a father to these children at all. When he did have custody of them, he had 8 different girlfriends take care of them.
Okay,
He didn't.
Jesse, you have to be there the whole weekend. Can you commit to that?
Yes, I can.
All right. Well, I'm going to, at this point, construe his motion to be a motion to enforce his parenting time, and the court will enter an order enforcing it. Amanda, you have to encourage these kids to go, not discourage them to go.
I have tried to encourage them, Your Honor. You don't
They've somehow gotten
understand
the
what
idea
we-
they can call their own shots. They cannot.
They don't call their own shots. I look out for their safety. Their
Well,
safety. This
okay.
man has put me at gunpoint.
Then you articulate to me why they're not safe with Jesse. Is there a criminal case pending?
Because
Has he been convicted or found guilty of abuse?
No.
I mean, what?
No,
what,
because
what
he
is the
threatened me
basis?
if I ever turned him in. He has threatened me if I've ever turned him in. I have plenty of PFAs against him from him physically abusing me and my son.
I'm not concerned with that right now because you two aren't together.
I'm
You're
just
not
saying.
gonna co-parent within the same house.
Okay, it has nothing to do with me. My children, I tell them if they want to go see their dad, they want to talk to their dad, they let me know, and I will make it a thing. They tell me, no way, I don't want to see him. I don't feel safe with him. They don't want to be around him because they're scared he's not going to bring them home. That's what he did the last
he's
time.
gonna bring them home.
That's what you
He'll be in
think, but
prison.
he's not. He won't though, Judge. And that's what my
Jesse?
kids are scared of.
Jesse, you understand what your finish time to your parenting time periods are?
Yeah, it's at Quick Trip, Friday night until Sunday, at 5 or 6.
Well, you need to check the order and make sure that you know exactly what that time is.
Yeah, I have it written down. Your Honor, I know.
Friday.
This case ultimately comes down to a single principle that applies across criminal and family court alike. Court orders are not suggestions. In the fraud case, the judge balanced mercy with accountability, imposing probation but adding jail time to address repeated misconduct in courtroom behavior. In the custody dispute, the court denied a custody change but firmly enforced visitation, making it clear that personal conflict cannot override legal obligations. The takeaway is simple: cooperation protects your rights, defiance destroys them. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.